Robin Millar.
Thank you, Madam Deputy Speaker, and thank you for selecting the amendments to Lord's Amendment 5. And I'd like to just firstly thank my honourable friend, the member for Northampton South, for bringing this forward, because I think what he's put his finger on is a couple of really important principles about how we do law in this country and how we legislate in this House. And I should start by saying that this is not about abortion. This is absolutely not about abortion. It also does not change the legislation with regard to buffer zones. This does not prevent buffer. The amendments he's brought forward do not prevent that. As has been said already, that debate has happened in this House. They are in place. In fact, Madam Deputy Speaker, the powers for buffer zones around abortion clinics already exist. This was a point made very well, I may say, by the honourable member for Ealing Central and Acton, who's not in her place, but she highlighted how, in fact, where they have been challenged, their presence has been upheld, and in fact, people within them protesting have been moved on. They are both legal and, it would appear from her description, they are effective for their purpose. We have, therefore, not only laws that provide for buffer zones around abortion clinics, we have also now some evidence of what those mean in practice. We have the evidence that there are laws which enable people to be moved on, but we also have something rather more disturbing, which is evidence that of the way that law is being interpreted. So I'd like to make 2 points, if I may, Madam Deputy Speaker, about law and how we approach it. The first one is, as a member coming to this House and being tasked with understanding issues that we debate, a wide range of issues and all sorts of things, one of the first questions I ask myself, and often one of the first questions that's asked of me, is what is the evidence for the need for this? And I think this question of necessity and proportionality is an important one, and in particular to the amendment that my honourable friend has tabled, seeking a pause in this legislation until we've established the need. That is an important question. Certainly before any kind of national provision is introduced, it's reasonable to ask what is the necessity and is it proportional. In 2018, I believe it was established that that wasn't there. And so I have to ask myself, standing here again, how has that changed and why is it felt necessary now? Is there a material difference? And I'm struggling, I must confess, in this debate to understand what objection there might be to providing that evidence or securing that evidence or actually having the confidence that we are acting proportionally and out of necessity on that evidence base. The second point that my honourable friend's amendment makes is to do with, effectively, a carve-out or a provision for this matter of silent prayer. Now, there is no support in this place, and I don't believe there has been throughout the passage of this bill, for any intimidation or harassment of women seeking the services of an abortion clinic. That's an important point, because this is not seeking to achieve that. We already have laws which will deal with this. What we do have is we have evidence of an arrest which took place for the act of silent prayer. And what this amendment seeks to do, therefore, is to make it clear that that is an inappropriate interpretation of the laws that we have. It seeks to prevent that point. Yes, I'll happily give way.
I thank the gentleman for giving way. This seems to be the nub of the challenge. Can he accept that whilst he does not feel that silent prayer would intimidate him, there are plenty of users of this service who do feel that it is intimidating? So actually it is right that it is in scope.
I thank the honourable member for making that point. She's clearly read my notes, because this is exactly the point I'm coming to. And what I would say as well in response to her earlier comments is that I do not seek to put myself in the place of one of those women who might be seeking the services of an abortion clinic. I respect the fact that that's an incredibly difficult moment. It's an incredibly sensitive, vital moment even. And so I don't seek to try and understand from a lived experience. I cannot, as she has made the point herself, understand it from that point. However, the point she has equally made is that, and she said it herself in her own remarks, was that it is the presence of the person in that place that is objectionable. Because actually we cannot know what silent prayer is. Honourable members here, they may well be silently praying that I wrap up my concluding remarks so that we can move to a vote. I have no way of knowing. Prayer is not necessarily marked by a folding of hands, a closing of eyes, a bowing of the head, a thumbing of a rosary. It's not necessarily marked by kneeling. Indeed, the evidence from what we already have of an abortion clinic with a buffer zone around it where an arrest took place was that the person was standing. And when challenged, was arrested on the basis that she was praying silently. There was no placard, there was no graphic image, as the Honourable Member for Ealing Central and Acton said earlier. There was no graphic imagery, there was no shouting, there was nothing. And this is the point of concern. How then do we know what the basis is for that arrest, if indeed it is just the presence of someone, perhaps who's in the habit of praying silently? And I conclude with this observation, Madam Deputy Speaker, and the importance of this comes to this. These three things: thoughts, words and deeds. Our freedom to think, our freedom to speak, our freedom to act. If those three exist on some kind of continuum, where we put the marker of where that freedom ends is really a statement about the society that we have. Do we place that marker just beyond the freedom to speech, effectively saying we must watch our speech and the things we say? Well, I think we have already established in the laws of this land that we do that. We do not allow people to speak freely and without consideration. But what we have seen here, through the implementation of existing laws, local laws, which this bill would now seek to make national, is an interpretation which says that we do not have freedom of thought. That is the point of my intervention, or that is the point of my contribution. That is the point I would suggest for the Honourable Member for Northampton South's amendment, and that is what I will be supporting. Specifically, firstly, a helpful and sadly necessary clarification that we do in this country enjoy freedom of thought and indeed to practice silent prayer. And secondly, because it's incumbent upon us when we make laws that we pause to test the need for further legislation before what would be unnecessary legislation is needed. Thank you.